What if one of the biggest constitutional battles in American history unfolded in less than 48 hours? A federal judge issues an arrest warrant. The president's legal team rushes directly to the United States Supreme Court. Then, before sunrise, the next morning, the Chief Justice steps in and temporarily stops everything. If true, the legal questions raised by such a scenario would be unprecedented. More importantly, they would force the nation to confront one fundamental question. Can a sitting president of the United States be arrested while still in office? Today, we're breaking down the legal arguments, the constitutional questions, and why this debate could shape the presidency for generations. According to the scenario, the legal drama began when a federal district judge issued an arrest warrant connected to allegations of perjury during sworn testimony, rather than waiting for the normal appeals process. President Donald Trump's legal team immediately filed an emergency application directly with the Supreme Court, arguing that the issue was too important for lower courts to resolve. Only hours later, Chief Justice John Roberts issued an administrative stay, temporarily preventing the arrest warrant from being enforced, while the Supreme Court considers the constitutional questions involved. It's important to understand what an administrative stay actually means. A stay is not a declaration of innocence. It is not a final victory for either side. Instead, it simply pauses the legal process until the court decides what should happen next. In other words, the warrant may still exist, but it cannot be executed while the stay remains in effect. The defense argues that arresting a sitting president would fundamentally violate the Constitution. Their position rests on three major arguments. First, they claim that the president occupies a unique constitutional office that cannot function if subjected to criminal arrests during a presidential term. Second, they argue that allowing judges to arrest the sitting president would upset the balance between the executive and judicial branches of government. Finally, they contend that the Constitution already provides a mechanism for dealing with presidential misconduct through impeachment, leaving criminal prosecution until after the president leaves office. Supporters of this position warn that if presidents could be arrested while serving, future administrations might face politically motivated criminal cases every time control of the government changes. They argue that such a precedent could make it nearly impossible for any president to govern effectively. Federal prosecutors, however, present a very different constitutional interpretation. They argue that the principle that no one is above the law applies equally to presidents. According to their position, presidential immunity cannot become a shield against alleged criminal conduct that falls outside official presidential duties. In this view, if someone commits perjury, that alleged offense is personal conduct, not an official act performed as commander-in-chief. The government also points to previous Supreme Court decisions emphasizing that presidents remain subject to the rule of law, although those earlier cases dealt with different legal questions. Prosecutors argue they reinforce the idea that the presidency does not place someone beyond judicial authority. The central issue therefore extends far beyond one individual. The Supreme Court would effectively be asked to answer a constitutional question that has never received a direct ruling. Can the judicial branch order the arrest of a sitting president, or must criminal proceedings wait until that president leaves office? Legal scholars have debated this issue for decades, but no modern Supreme Court decision has provided a definitive answer. That uncertainty explains why constitutional experts across the political spectrum often agree that questions of this magnitude belong before the nation's highest court. The consequences of such a ruling would be enormous if the court ultimately concluded that sitting presidents cannot be arrested while serving. Future presidents would receive broad protection from criminal process until their terms ended. Supporters would argue that such protection preserves the independence of the executive branch and prevents politically motivated prosecutions. Critics, however, would worry that such a rule could place presidents beyond immediate legal accountability. On the other hand, if the court concluded that presidents may be arrested while in office, supporters would say that the Constitution treats every citizen equally before the law. But opponents would warn that hostile prosecutors or politically opposed judges could repeatedly interfere with the functioning of the presidency. Neither outcome is without significant constitutional consequences. The stakes extend well beyond legal theory. Every Supreme Court ruling involving presidential powers becomes part of constitutional precedent. Future presidents, regardless of political party, would likely operate under whatever rule emerges from such a decision. That is why observers often compare disputes involving presidential authority to other landmark constitutional cases that shaped the balance of power between the branches of government. The court would not simply be resolving one legal dispute. It would be defining the limits of presidential authority for generations. For the American public, the immediate practical effect of an administrative stay would be straightforward. Law enforcement could not execute the arrest warrant while the stay remained in place. The legal battle would shift from trial courts to the Supreme Court, where the justices would determine whether to hear arguments, request additional briefing, or issue a broader constitutional ruling. Every filing, every order, and every decision would be closely watched, because each step could signal how the court intends to approach one of the most consequential constitutional questions in modern history. At the same time, legal experts would caution against reading too much into an emergency stay itself. A temporary pause does not reveal how the court will ultimately rule. The justices often grant emergency relief simply to preserve the status quo while carefully considering exceptionally important constitutional issues. Only the final opinion would determine the actual legal precedent. Ultimately, this debate is not solely about Donald Trump. It is about the structure of the American constitutional system. How much protection should the presidency receive? How should the judicial branch hold the executive accountable? And where should the balance between presidential independence and the rule of law be drawn? Those are questions that extend far beyond any single administration. Whatever answer the Supreme Court eventually provides would almost certainly influence every future president and every future constitutional crisis for decades to come. Until that final decision arrives, one thing remains certain. The legal battle may involve one president, but the precedent could shape the presidency itself.